Okay, when is an employer liable for the acts of his or her agent? That is, a person, their employee, or someone that they hired to act on their behalf. When can that person's conduct create civil liability or liability in tort for the employer? What controls that is a doctrine called respondeat superior. It basically means that the agent is acting on behalf of or responding to the commands or will of the employer. And in that sense, the agent's actions can cause vicarious liability for the employer. Vicarious liability means liability for someone else's actions. So the employer will be held vicariously liable for the agent's actions. The basic standard is the agent or employee has to be acting within the scope of their employment. Now, within the scope of their employment is a broad term. It could be that the agent is simply doing the menial tasks that are in support of the job. It doesn't have to necessarily be that the agent is specifically doing something that the employer told them to do. It simply has to be in pursuit of or in furtherance of their job, position, duties, etc. Now, that begs the question, when is an agent acting outside of the scope of employment? When they are, that is called a frolic and detour. Okay. That means the employee steps outside of the course or scope of employment and acts for his or her own interest. In that case, any harm or civil wrong that they commit to a third party would subject themselves to liability, but the employer would not be liable for that conduct. Say you have a situation where an agent and employee delivers packages for a business. Okay. Now, if that employee gets in an accident, rear ends somebody in a vehicle while they're driving to deliver those packages, that is obviously within the scope of employment. If the person who is rear ended is injured, they may sue the business and seek any form of damages or remunerations for damages that they've suffered. But what if that employee, instead of getting in a wreck when they were delivering the packages, they went outside of the scope of their employment? They were using the company vehicle for personal reasons while they were during the weekend or while they were on vacation, something outside the scope of what they were allowed to do within their employment. And their purpose in using the vehicle was not in furtherance of a business purpose. Now, if they were to get into an accident at that point in time, that would be considered a frolic and detour. They were not in pursuit of the company's business, and they were not in a scope of employment. So again, that would exceed the scope of employment and would not subject the business to liability.